A very good day from Dr. Gifty, Oommen. I take this opportunity to thank my Lord God Almighty and the organizer for giving me this opportunity to talk on this topic. The topic of this day is patent nature for sale. Now, why did I take this topic? This topic is very relevant today, especially with the topic which we have, that is liberty. Liberty in patent law is creating a lot of problems. The nature, a part of the nature, slowly but slowly is coming under the grab of the monopolies, the corporate sectors. We have to be very careful about it. Many things in the guise of scientific temper and scientific enhancement is coming under the grip of certain multinationals. We cannot allow this to be done. We all know about GATT 1994, wherein brought in, and as a result of which we brought in the Patent Act, Section 3. Section 3 of our Patent Act talks very exclusively about certain exclusions, such as any duplication of the nature, any part of the nature, any discovery, any scientific knowledge, whatever which is exclusively belongs to nature cannot be made the monopoly of some other people. That is exactly what we're talking about. So when we're talking about it, we need to know then how is it that certain part of the nature is going under the hands of certain people. But just for that sake, I like to just go over a few cases. The first case that I would like to take is the case of Funk Brothers versus Calvin in 1948 Supreme Court of US, where it was a question of leguminous plants. Rhizobium species we know is used by the leguminous plants for nitrogen fixation. These rhizobium bacteria are found in the root nodules of these leguminous plants. Now, this is a very mysterious process, something that we cannot understand possibly, and for which man doesn't have to do anything. It is a naturally occurring process. In this case, it was understood that certain rhizobium species are not compatible with certain leguminous plants. So therefore, what Callow did was, he made an assemblage of some species of rhizobium and he isolated them in such a way that when they were put in a package and when they were sold and when they were put as a fertilizer, the particular rhizobium species which was compatible with this leguminous plants which operate, while others will remain which are actually non-compatible, they will remain dormant. So therefore, as a result, the particular rhizobium will operate. What he did was he just made an assemblage of it. And when this matter came before the court, Justice Douglas said very specifically, this nature's working, rhizobium help for nitrogen fixation is something which is in the nature. It's a mysterious process which we don't know how it happens. And this process where different rhizobiums are made to function for different leguminous plants is also something which the agriculturists know. So what they have done is only made it a little more easy. So what Justice Douglas says was, this is something which is in the nature and this possibly cannot be given patent. But later in 1972, 1980, as we know in the case of Diamond Chakravarti's case, Ananda Chakravarti, what he did was, he actually genetically modified a bacterium and he put in many things into the bacterium so that its natural working itself changed. In a sense, this bacterium started eating on this oil spillage from on the high seas. And this was because he had modified the bacterium. They were able to convince. We know there was a big battle between Diamond and Chakravarti, but ultimately the Supreme Court of US agreed that he had genetically modified. And as the court also understood that this was very much needed, otherwise maybe the developments in microorganisms would not get that inch which they should get in today's world. And as a result, they allowed it to be given patent. But one should understand that the cost we paid because of the 1980 decision, even Dr. Albert Einstein and many scientists have made many things and discovered many things for the scientific world, but they have never been very persistent about patent. But at the same time, they are known personalities. But what they studied, what they acquired, they gave back to the society. But strangely, today we find a different system where they learn, they acquire, but they keep it to themselves and they don't give it back to the society. And when they do give it, they give it to that select few people for a very high price. This is exactly where scientific temper goes against today's way of using scientific knowledge. We need to go in depth about it because this is something which should not be allowed. The nature is definitely not for sale. The nature belongs to each and every human being. And if there is a scientific knowledge understood from that, it should again be given back to the public domain so that further enhancements in scientific investigations can take place. When these people get a monopoly in it, then there are a lot of legal litigations which come in. It's very difficult for anyone to freely work on them. That is what I want to talk to you about. Later on, we found in case, as a result of Diamond Chakravarti's case, a lot of discussions came in, a lot of interest developed in microorganism because they realized this can possibly be given patent, and that is definitely microorganism is part of nature. And the discussions finally ended up in 1994, where we found that microorganisms were allowed to be given patent while plants and animals were not. Why? What is the distinction between them? All belong to the nature. But we could not understand it because there was a lot of other things moving around the minds of these people. And as a result, in 2002, we also in India accepted this amendment. And in 2002 itself, there was a case of Dominica versus Controller of Patent. I think it was a Calcutta High Court, where it was about a vaccine which was asked to be given patent. And the patent office denied the patent, saying that there was no substance or product created, and was something connected to living being. But the appellants, the company, came against the argument and said that this patent office had earlier given patent to cells and viruses, which the patent office said was given because they were dead. And the argument of the appellant was these cell viruses were not dead, they were only made dormant. And that is exactly what they contended. As a result, the court struck down the order given by the patent office. Now, how sharp was the argument? You can realize that. And finally, the company was able to get patent on it. But we realized a shift took place in 2013 with the Myriad case, where the Supreme Court of US came against it, and where BRCA won, which was actually isolation of the ovarian cancer cell and breast cancer cell done by universities, various universities in America, particularly University of Utah was ahead. And when they wanted, and they got patent, many of them had isolated and got patent over that cells. But when this matter came up, the court said that is not allowed. What the court said was, this is something that is already in the nature. The DNA sequence which you have isolated is part of nature. You have not done anything to it. What you have done is only isolated it. And therefore, that cannot be allowed to be given patent. And this is exactly what they stated in 2014 in the case of Rosin case also, regarding cloning of dolly sheep. And this being the discussions in US, we find in certain European countries this is not so. In certain European countries, isolation of certain cells and viruses and bacteria are being given patent. This is a very disturbing factor, especially in the case of today's COVID-19 virus problem that we're suffering. If these SARS virus is being isolated and given patent to certain corporates, then the problem is anyone wanting to do further research or bringing in a vaccine for this, they will have a tough time battling the legal litigations involved in it. So therefore, we need to think very sharply. This is not just for debate's sake, this is not just for discussion's sake. This is something which should evoke the humanity and the emotions and the logic of what is scientific temper and what is commercial exploitation of scientific knowledge. We need to be very clear. We need to draw a veil between these two things, because there is a very thin veil between both of them. It depends on the contentions raised. We academicians, we lawyers, we people who talk about humanity, at the same time we talk about liberty, we need to understand that nature is definitely not for sale. Nature belongs to the world, and any common investment, any common knowledge, anything coming out of the nature is for the commonness of the people. And from there we need to bring in medicines and vaccines for the people. If only this knowledge is open, can we do something about it? So therefore, this is where I like to conclude it. Bring in you people, provoke you people to come to the point and say once and for all that our nature is definitely